First matter to come before us this morning is State of Ohio versus Jill Tucker. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Should the appellant wish to reserve any time, if you let me know when you get started, I'm keeping the clock this morning. You can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
May it please the court, my name is Brad Proudfoot and I represent the appellant Jill Tucker. At this time I'd like to reserve 3 minutes for rebuttal. Your Honors, we are here today to review the trial court's jury decision finding Jill Tucker guilty beyond a reasonable doubt of one count of aggravated arson in violation of Ohio Revised Code 290902A1. Ms. Tucker is seeking reversal of the trial court's denial of Tucker's request for criminal Rule 29 motion for judgment of acquittal, and remand to the trial court to dismiss the charge, or in the alternative, reverse the trial court's decision and remand the matter for a new trial. In our briefs, we raised 3 issues for review. First, was there insufficient evidence relating to the elements of aggravated arson, in particular the substantial risk of physical harm to any person other than the defendant to convict the defendant? Second, was the trial court's denial for a criminal Rule 29 motion for acquittal incorrect in light of the testimonial evidence of substantial risk? And finally, was appellant's conviction for aggravated arson against the manifest weight of the evidence in light of the minimal testimony evidence of substantial risk of serious physical harm to any person other than the defendant? Your Honors, we'll start with insufficiency of the evidence in the criminal Rule 29 motion for acquittal. As you know, any challenge to the sufficiency of evidence questions whether the evidence at trial was sufficient as a matter of law to support the defendant's conviction. In determining that the evidence must be legally sufficient to support the jury's verdict as a matter of law. The basis for Ms. Tucker's assignment of error is the application of subsection A1, essentially create a substantial risk of serious physical harm to any person other than the offender. It's our contention that the state did not meet their burden of proving beyond a reasonable doubt that there was substantial risk of serious physical harm. Now, serious physical harm, or substantial risk, is defined in 2901A8. Substantial risk means a strong possibility, as contrasted with a remote or significant possibility that a certain result may occur or that certain circumstances may exist. There's no other guidance really given within the Ohio Revised Code as to how to define or differentiate between remote, significant, or strong. I'd like to move right into State v. Stewart.
Before you do that,
yes.
I want to make sure I understand your position. You don't take issue with the fact that firefighters go into a burning house, that there is a risk of injury?
No, I do not take.
Okay.
Obviously, with firefighters, there's always a risk of injury.
And in the facts, given the facts of this case, as I read the briefs, and construing them in the light most favorable to the state, we have a situation where your client advised the responders that the fire was in one location in the house, and that was their expectation, that they were just fighting that, so that it wasn't until they got that somewhat contained that they then learned that there was another hot spot and began moving in that direction. Now, at that point, are they exposed to a substantial risk of harm?
I'm assuming you mean as they were being told to go to the second floor of the home? In Assistant Chief Likely's testimony, he had stated that at some point he had told them to go ahead and move up to the second floor, but he also stated in that testimony he wasn't sure, he couldn't recall whether they actually did proceed up to the second floor or he had already identified a possible risk of backdraft or flashover on the second floor and pulled them out. And I didn't see anywhere else in the transcript that said that they actually did proceed to the second floor.
And let's assume that they did not. How are we to look at the testimony regarding the windows that blew out on the first floor, just from the sheer heat?
Well, the windows on the first floor that were off of the addition that was added on, I believe it was 2 police officers that were standing there. And I believe that the testimony was they were 8 to 10 feet away from the window and that it did explode. But there was no testimony that anyone was injured, that any glass actually struck anybody.
Well, but that's not the test, is it?
Well,
it's substantial risk of harm, not that they have to actually have physical harm.
Correct, correct. Going back to State v. Stewart, it was actually, this court held that based on all the evidence presented, a rational trier of fact could have concluded that the state presented sufficient evidence of aggravated arson. Stewart had argued that his convictions were based on insufficient evidence because the state failed to prove that he knowingly created or caused the fire that broke out in his home. The state here, in their brief, they argued this point, and they point out paragraph 13 and 10 of the decision that respectively state the responding firefighters broke down the door of the defendant's home and proceed to the second floor, but the intensity of the heat forced them to retreat. That was paragraph 13. And then in paragraph 10, the police officers also evacuated neighboring homeowners because they feared the fire might spread to their homes. I take a little bit of issue with that because in Stewart, the argument wasn't that they were at substantial risk of harm. Stewart was arguing that the state had failed to prove that he knowingly created or caused the fire that broke out in this home. So he wasn't even arguing that portion. That was more in a recitation of the facts of the case. And so I understand that that could be construed as a substantial risk, but it was not used in the reasoning or rationale of the court at that time. What was in front of them was the argument that they failed to prove that he knowingly created or caused the fire itself. Also in State v. Keogh, which was referenced in the state's appellate brief, the 6th District Court held the weight of the evidence supported defendant's conviction for aggravated arson because the defendant created, through the use of gasoline and a space heater, a substantial risk of harm to the volunteer firefighters whose duty it was to respond and put out the fire in their home. In that case, they go on to state, the state does, in their brief on page 12, that the 6th District held that by intentionally setting the fire, the defendant had created a substantial risk of harm to the responding firefighters. And I don't think it's not the intentional setting. I don't think that's ever really what the statute is arguing, that anytime you intentionally set a fire that there's a substantial risk. I think that it goes back to the actual facts of the case. And in this case, what was stated was that there was a backdraft situation when they first arrived.
They didn't know it.
Well, actually they did. They recognized it when they first arrived. I'm talking still about the State v. Keogh.
Oh.
I was going to differentiate that with this case.
Go ahead.
So there was a backdraft situation there, and it existed from the very beginning because the firefighter that had responded in this case, in Keogh, was a next door neighbor. So he showed up, he recognized that there was a backdraft, and that you couldn't open a door or window in that entire house, or there was the risk of it blowing. So then they had to drill a hole through the top of the roof, let it come out that way. In this case, we don't have that initial backdraft problem that's seen later on in the second floor here in Ms. Tucker's case, where there could have possibly been a backdraft situation on that second floor.
So what difference does it make whether it was evident at the time that they arrived, or even if it existed at the time that they arrived, or if it later came to be? What difference does that make?
Well, I think in our situation, they never, well, I didn't see any testimony that they ever actually went to the second floor or were exposed to the situation.
I don't believe that's what she's asking.
I apologize.
I don't think there at any, we don't know at any given time when a backdraft situation occurred. It could have been there the moment they arrived and didn't know because they weren't aware that there was a fire on the second floor too. Nobody really knows. So, and because there was never any disclosure about there might be something somewhere else, they unknowingly could have gone.
Correct.
And subjected themselves to something that nobody knew about. So
yes,
that's the risk, right? There's
always the unknown harm in any fire, and I believe that has been stated in a couple of the cases that were cited. We also spoke about there was also State v. Polking, and in that case, which was cited by the state, the evidence of an imminent roof collapse was sufficient to establish the element of substantial risk of serious physical harm. In this case, we're not arguing that an arsonist is an excuse for ever exposing a firefighter to unknown elements of harm, as Your Honor was speaking to. Essentially, in this case, on page 6 of the brief, it says they claim that the firefighters always face a risk of serious physical harm. And I don't think that's necessarily the case, that you always face that substantial risk of serious physical harm. I think that's the reason why firefighters were added to the statute. And we have the 3 tiers, the remote, the significant, and the strong. So I don't think just exposing them. So I don't think that State v. Polking is a good analogy to this case. And also, the state wrote of State v. Lincas, and in that the 4th District stated, moreover, being in proximity to the flames is in itself a substantial risk of serious harm. Additionally, the bystander stated that every time he tried to approach this vehicle, something up front, whether it be a tire or whatever, would explode on the vehicle. And then the court goes to say, certainly an explosion resulting from the fire presented a substantial risk of serious physical harm to the bystander. I understand the argument there, or the analogy to the window actually blowing out on the back addition of Ms. Tucker's home, and trying to say that's analogous to the vehicle that was set on fire in Lincas. I think that there's a slight difference. In Lincas, the bystander was continually attempting to get into the home as this was going on.
Counsel, you're just now reaching into your 3 minutes of rebuttal time. And continue or reserve as you wish.
Well, in conclusion, then, upon application of the sufficiency of the evidence standard and the manifest weight of the evidence standard, Tucker's illustrated that after viewing the evidence in light most favorable to prosecution, no rational trier of fact could have found essential elements of the crime beyond a reasonable doubt. For the foregoing reasons, Tucker respectfully prays that the decision of the lower court was an error, and that this court either remand to the trial court to dismiss the charge, or in the alternative, reverse the trial court's decision to remand the matter for a new trial. Thank you.
Good morning, Your Honors. May it please the Court, my name is Matthew Kern, and on behalf of Dean Holman, the Medina County Prosecuting Attorney, I represent the state of Ohio in this matter. The issues before the Court today all revolve primarily around the facts of this particular case. The first assignment of error challenges the manifest weight of the evidence, and the second and third assignments of error challenge the sufficiency and the trial court's denial of the Rule 29 motion. The state has kind of consolidated the sufficiency and Rule 29 issues in its brief, and I'll argue those together today for the same reasons, because there really wasn't any additional evidence the state relied on presented from the defense case, so it all came from the state's case in chief, so they would be based off of the same standards. The only challenge you've heard today regarding the sufficiency of the evidence in terms of an element that the defendant is challenging is whether the state's proved that that there was a substantial risk of serious physical harm. There's no dispute that Ms. Tucker set the fire. There's no dispute that it caused harm to the occupied structure or to the house, the property of her, that it was done. There's no dispute that there were 2 independently set fires. There's no dispute that there were nightable liquids used. There's no dispute that as a result of her actions, the firefighters responded to the scene. Her only challenge today is that her actions, in her view, did not present a substantial risk of serious physical harm. You've heard a lot already from Mr. Proudfoot about some of the cases that we've cited. In all of these cases, from the 8th, 6th, 10th districts, the courts have regularly found that situations like those here, where there are backdraft potentials, where vehicles or other items exploded and sent material flying towards either bystanders or emergency responders, where there was a risk of structural collapse. All of those situations, courts across this great state have held that there is a substantial risk of serious physical harm.
Was there something presented about a risk of physical collapse of the building?
Not specifically, Your Honor. I think that when the court considers the backdraft scenario, I think it's clear from the record not just that the flashover event, which would cause degrees, I think the assistant chief or one of the firefighters testified that temperature can reach up to 1,000 degrees Fahrenheit, and regardless of the gear that firefighters wear into a burning structure, oxygen tanks, flame retardant, suits, nothing can withstand that 1,000-degree heat that they would be burned. That testimony came out in the trial. So that backdraft flashover situation they're describing is very real, and just because the chief recognizes that is a potential in this situation based off of the thick, heavy black smoke he began to see come out of the second story, which by the time he saw that the first downstairs living room, the supposed scented candles that had been lit, which were inconsistent with the actual way that the burn patterns and the fire was observed that day. I think that backdraft, the flashover event, the extreme heat, I think it's reasonable to believe that an older house, that the older portion had the balloon construction, the one witness testified, that I think is reasonable to believe, and the jury could find that it's likely that would create enough lack of structural integrity that there would be at least some risk of that, whether that's a substantial risk itself for the court to decide. But backdraft, flashover, the bay window blowing out 8 to 10 feet away from police officers who were first on the scene. Just because they were not actually struck, as Your Honor pointed out just a minute ago, just because they are not actually struck does not mean that there is not a substantial risk of serious physical harm. Flying glass shards by the face, neck, vital regions of these emergency responders coming to the scene of what they think is an honest emergency places these officers and places eventually the firefighters who responded to the flame in a substantial risk of serious physical harm. Just because it is emergency responders, police, firefighters' job to respond to emergency situations does not mean that people who intentionally set fire to their own home for financial gain escape from aggravated arson convictions. They put emergency responders in danger, and in this case, Ms. Tucker specifically withheld critical information from firefighters who responded on scene and placed them in greater danger than they needed to be in. Had they known there were 2 separately set fires, they would have responded differently to this situation. They would not have sent in emergency responders just to the family room. They maybe would have started another master stream up to the second story had they known that there was that situation up there, building as they were in the house downstairs inside the cubbyhole. The irregular V-shaped burn marks, the scorched carpeting, all of that is consistent with the evidence that this was a second intentionally set fire. And you don't hear a dispute about that today. It's not assigned as part of the error for this court. 2 separate ignition points, both aided by ignitable liquids. inconsistent with her version of events. Her inconsistent version, what lay people might refer to as a lie of omission or a misdirection. Those things place these firefighters in additional danger. In State versus Miller, a case that Mr. Crawford today doesn't address, a fire chief testified about the risk of a backdraft, structural collapse, and smoke poisoning firefighters which they face in entering burning structures. In that case, the 10th District held that in a backdraft situation, the court noted that firefighters entering an enclosed area may introduce oxygen to the fire, creating a risk of explosion. The defendant's use of ignitable liquids, in that case gasoline, also caused the fire to burn hotter and faster and increase the risk of a structural collapse because the gasoline can seep into the flooring. The court, 10th District, held that the defendant was aware that as a result of using gasoline to set a house on fire, emergency personnel would respond to the scene and enter the house to extinguish the fire, placing their own lives in great danger. That's paragraph 33 of the opinion in Miller. Firefighters do a tremendous public service. They put their lives on the line for everyone. And in doing so, they perform a great public service. But they would respond differently to a situation had they known what was actually happening, had they been aware of the full extent of the facts. Just because the assistant chief recognizes as the firefighters are on the first floor working their way up towards the second floor of the house, had they known about the second fire, had they known about the additional situation upstairs, they may have responded differently. The fact that they are inside the house as a second fire is burning, about which they are otherwise unaware, places them in substantial risk of being seriously physically harmed.
So, do you recall whether there were any jury interrogatories conducted in this case? And I'm asking specifically from the standpoint of we don't know whether the jury found the substantial risk of harm flowing from the windows blowing out or the officers going, to the second floor or toward the second floor.
I do not recall any interrogatories. It's been some time since I've read the transcript, and preparing for today, I don't recall seeing an interrogatory. There may have been. But the other thing I would say about that, Your Honor, is obviously when the jury returns a verdict, it is a general verdict, and they do not answer special. So even if there were interrogatories, that would not necessarily make clear for the court what they were basing their verdict on. It's entirely possible that they could have asked a question about the windows and made their verdict based off of the firefighters or vice versa. And I think in the absence of specific evidence of what they were intending, i.e. in a civil case, an interrogatory of that nature, I think that it's almost impossible to say specifically what they were looking at. And so the court's review, in your appellate posture, I think you'd have to look at what is the evidence. Is there any evidence which supports the jury's verdict? And if so, under Jenks, under Jackson v. Virginia, if there's any evidence, competent, credible evidence, well, credible for manifest weight, if there's any evidence in the record which supports the jury's decision such that a rational trier of fact could have found all of the evidence proven beyond a reasonable doubt, your role is to affirm. And in this case, unless the court has further questions, I will yield back whatever time I have remaining and respectfully urge the court to affirm the conviction and sentence below. Thank you very much.
You have just over 2 minutes remaining, Mr.
May it please the court, there's just one issue or one question that I wanted to address that you had placed to Mr. Kern. You asked if there was a risk of collapse of the home or anything along that line. I do remember it reading in the transcript that Assistant Chief Likely at some point had said that there was no chance of the floor itself collapsing. He didn't recognize, I believe the word was a sponginess to the floor. I'm assuming that's indicative of the possibility of a floor giving way. And as such, for the foregoing reasons, Tucker respectfully prays that the decision of the lower court was in error and that this court remand to the trial court to dismiss the charge on the alternative, reverse the trial court's decision, and remand for a new trial. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be linked to through our website. Thank you.
Thank you.